speaking in the name of the law, not in speaking for ourselves as individuals.
We'll come to order. Senator Blumenthal.
Thank you very much, Chairman. Thank you for being back, Your Honor, and thank you to your family as well. I want to just begin by saying, perhaps not surprisingly to you, that I was really disappointed by your responses to a number of my colleagues, most recently to Senator Coons, on the issue of whether you would participate in a decision involving the upcoming election if you are confirmed. I continue to believe that if you were to participate in a decision involving that election, it would do enduring explosive damage to the court. I think you know it would be wrong, not because of anything you've done. In fact, I'm not raising the issue of whether you've done any sort of deal or commitment because of what Donald Trump has done and my Republican colleagues, because they have indelibly put at issue your integrity through their statements. The president has said that he's putting you on the court as a ninth justice so you can decide the election. He's been very clear and transparent. And the American people are not dumb. They're watching and they're listening. And if you were to sit on this case, if it goes to the Supreme Court, the American people would lose faith and trust in the court itself. It would be a dagger at the heart of the court and our democracy if this election is decided by the court rather than the American voters. So I wanted to begin by making that point and then go to, again, the real people who are really in this room with us and who will be affected by you as a justice. Yesterday, I introduced you to Connor Curran, you may recall. He's 10 years old. I was with him on his 10th birthday, September 27. He's a remarkable champion. He was diagnosed, as you may remember, with Duchenne muscular dystrophy at age 4. His parents were told to take him home and give him a good life because he would soon lose his ability to walk, told his muscles would get so weak that he'd eventually lose his ability to smile, and still smiling. What lies behind that smile is untold pain, physical pain, the anguish of going through the needles and the prodding and the treatments. But for his family, it's also the anguish of wondering whether they'll be able to pay for treatment that has kept him alive and whether he will be with them for all of life's milestones. They sent me a letter that they asked me to share with you, saying to you, Judge Barrett, please protect Connor. And they wrote also for millions of other Americans, 135 million Americans, many of them children, just like Connor, but also Christine Miller from Bloomfield, Connecticut. She was diagnosed with a thyroid condition. Her condition was only discovered because of the ACA, which gave her affordable coverage for the first time in a long time using Connecticut's exchange, healthcare exchange. And they wrote for people like Julia Lanzano in Cheshire, Connecticut. She suffered from headaches for years, and she put off going to a doctor because she lacked insurance, so typical and common for people. Put it off. When Julia finally saw a doctor still without insurance, she learned she had a brain tumor, and she was eligible for coverage under Connecticut's Medicaid expansion program, which was created by the Affordable Care Act. In her words, it was a godsend. I raise these stories in part because, as you know, I'm sure, protection for people who suffer from pre-existing conditions is in fact on the line in this case that will come to the Supreme Court only a week after the election. I want to be crystal clear because you stated to Senator Feinstein that, and I'm going to quote, so far as I know, the case next week doesn't present that issue. It's not a challenge to pre-existing conditions coverage or to the extreme lifetime maximum relief from a cap. And technically, you're right, but, it's a big but, if the trial court is upheld and there's no severability, the entire act goes down. That is what the Trump administration is asking the court to do. That's what the plaintiffs want done. Correct?
I gathered that's Senator Coons had shown the brief with the litigating position
Right.
of the Department of Justice.
I want to move on to another healthcare case, and this one involves some of the letters that Senator Hawley was mentioning, and I feel I need to raise them because Senator Hawley asked about them, so did Senator Leahy, and I want to just clarify what they mean. And I want to make absolutely clear, I detest and oppose any religious test. I am not asking you any questions about your religious beliefs.
Okay.
I'm going to be asking some questions about your legal position. So in case I'm unclear in any of my questions, I want you to tell me.
Thank you, Senator.
You signed onto this 2006 open letter sponsored by an organization then known as the St. Joseph's County Right to Life, which was published in the South Bend Tribune. Is that the letter that Senator Hawley was mentioning?
I believe the statement that's on the left, I think Senator Hawley had read the language. I can't remember it verbatim, but it was something like, you know, we support the right to life from fertilization to natural death. Yes.
The letter and ad referred to Roe v. Wade's legacy as quote unquote barbaric, correct?
I don't think that that's part of the statement. I think that's part of the ad that appeared on the page next to it.
They appeared side by side, correct?
I believe that it ran that way in the newspaper. I'm not sure that I ever saw it in the newspaper, but yes, that is my understanding.
That's how it appeared, so they were side by side.
That's based, yes, based on since, yeah.
And the St. Joseph's County Right to Life sponsored the letter that you signed.
I think the St. Joseph County Right to Life organization was the one who presented the statement that I signed at the back of church.
I want to give you an opportunity to clarify. You didn't disclose that letter when you were nominated to the 7th Circuit in 2017, did you?
I did not, Senator Blumenthal, and I'm actually very glad that you brought that up because I just want to clarify for the record, number one, that I didn't have any recollection of that letter. I signed it almost, or the statement. I signed it almost 15 years ago, quickly on my way out of church. And, you know, the questionnaire asks me for 30 years worth of material, and I've produced more than 1,800 pages, and so I didn't recall it. After it came to my attention, I did go back and look at the questionnaire, and I actually don't think that particular statement is responsive to question 12, which is, I think, the closest that it would come. I don't think it's responsive, but in any event, it is part of the public, you know, record, and I'm very happy to discuss it. But
It's
I
part of
wasn't
the
hiding
public
the ball.
record now, and it's a letter. The questionnaire asked for letters. Have you disclosed it now? Have you provided it officially?
So, Senator, as I said, I've supplemented my questionnaire with other material that came to light that I do think was responsive. That one, and I would be happy to answer questions if you wanted questions for the record with more specific detail, but I did not understand that to be responsive to question 12, I think it is.
Well, in fact, we know about it only because The Guardian made it public, I believe. Let me ask you about another letter, 2013 letter. You signed on to this letter regarding Roe v. Wade. It was sponsored by the University Faculty for Life at Notre Dame. You're a member of that organization, correct?
I do.
And the letter described Roe v. Wade as, it's behind me, infamous. And it stated that the signatories, quote, renew our call for the unborn to be protected in law. Correct?
Yes, I believe the full statement says, I'm testing my eyesight here, our full support for our university's commitment to the right to life, because, you know, Notre Dame is a Catholic university and embraces the teachings of the Catholic Church on abortion. And so as a faculty member and member of the University Faculty for Life, I signed that statement.
But you didn't disclose that letter.
Again, Senator, I produced 1,800 pages of material, and all 6 prior nominees have had to supplement because they've overlooked things. 30 years worth of material is a lot to try to find and remember.
You disclosed it, in fact, just about 3 days ago, I believe, right?
Because that's when it was brought to my attention. I had no recollection of it, and it surfaced in the press, and so it came to my attention, and then I supplemented. And I did think it was responsive because it was a statement of an organization of which I was part, and I belonged to the University Faculty for Life at the time.
If this process maybe had been a little less rushed, you might have had more time to go back and recall some of these documents?
Well, Senator, as I said, all 6 prior nominees, or the most recent 6, have had to supplement too. So I don't think it really had anything to do with time. I think it has to do with the volume of material.
And when you and I spoke, when you appeared before this committee in connection with your 2017 nomination, I didn't have the benefit of any of these documents, although I asked you about right of privacy and the validity of Roe v. Wade, correct?
Senator, I said on my SJQ when I was nominated to the 7th Circuit, and I said again now, I produced all the material that I could find, and I conducted searches to try to find things that I forgot, and I didn't find that. I understand that someone had to manually go to Notre Dame and look through back archives. I didn't remember it, and I couldn't find it. I assure you I was not trying to hide it from you.
So, Judge, and I apologize for interrupting you. I'm
No,
pressed for
go ahead.
time.
Sure.
Respectfully, I want to share another healthcare story with you. This is about Samantha. One night in January 2017, Samantha went out with a few friends and coworkers. She woke up the next morning in a coworker's home, confused, scared, covered in blood. She'd been raped. After she was raped, Samantha was, in her words, a zombie. She couldn't change clothes, she couldn't shower, she couldn't drink or think. She wanted this event to be erased from her memory. Samantha's attacker also began stalking her, and she was struggling with depression and PTSD. In March, Samantha took a pregnancy test, and then another, then another. They kept coming back with the same result, pregnant. After the horrible violence she faced, she simply couldn't process that she was now pregnant. When Samantha shared her story with me, she said, I knew if I couldn't end this pregnancy, it would end me. So she decided to get an abortion. Now, as you know, Judge, the landmark Roe v. Wade decision gave her that option. It gave women the right to decide for themselves whether and when to have a child. Roe didn't compel Samantha to get an abortion. It didn't tell her what she had to do, but it gave her that choice. The question that I would like to ask you concerns your legal position. Does the Constitution protect Samantha's right to have an abortion?
Roe versus Wade clearly held that the Constitution protected a woman's right to terminate a pregnancy. Casey upheld that central holding and spelled out in greater detail the tests that the court uses to consider the legality of abortion regulations.
Now, I'm asking you this question because the group that sponsored the first letter, St. Joseph's County Right to Life, as it was then known, states, quote, "Abortion is never the right answer, even in cases of sexual assault or where the pregnant woman's life is in danger." And the purpose of the letters that you signed seemed to be a statement of legal position, but you're saying that there is a constitutional right to an abortion.
Senator, the statement that I signed from the St. Joseph County Right to Life didn't say anything about rape or incest or any of those things. It simply validated the teaching of my church on the sacredness of life from conception to natural death.
What I hear you saying is, in the Constitution, there is that right.
You mean when I was talking about Roe and Casey a moment ago?
Well,
Yeah.
Roe was correctly decided. You're agreeing that
What I said was that Roe held that the Constitution protects a woman's right to terminate a pregnancy, that Casey reaffirmed that holding, and indeed, many cases after Casey have affirmed that holding again, Whole Women's Health, for example. So I think we might be talking past each other because the statements that I signed were statements of my personal beliefs and not...
Not your personal belief, Your Honor, your legal position. Are you willing to say that Roe was correctly decided? Because that's really the essence of the question here.
Well, Senator, as I've said, to others of your colleagues in response to questioning, that it's inconsistent with the duties of a sitting judge, and therefore has been the practice of every nominee that sat in the seat before me to take positions on cases that the court has decided in the past.
Well, I think Samantha and a lot of rape survivors would be really deeply fearful about that answer because it provides no reassurance that you believe that Roe was correctly decided. Let me talk about Tracy. I want to tell you about her because she, again, came to me, told me she was diagnosed with stage 4 endometriosis and that it had caused an ongoing inability to have a healthy pregnancy. But as she said, she was one of the, quote, lucky ones. She had access to care and was able to receive treatment to assist in getting and staying pregnant. And I have encountered, maybe you have, many members of the military, veterans, who have sought similar kinds of treatment, and some of them because they've suffered wounds of war. Tracy was scared when she saw the executive director of the St. Joseph County Right to Life recently stated, and I quote, "We would be supportive of criminalizing the discarding of frozen embryos or selective reduction through the IVF process." So Tracy wanted me to ask you, in fact, she asked me to pose this question, is it your legal position that making IVF a crime would be constitutional?
Well, Senator, the statement that I signed, as we discussed, affirmed the belief of my church with respect to matters of life.
I'm not asking about what you signed. I'm asking about your present legal position.
But what I was...
Is making IVF a crime
Senator,
constitutional? Sorry, go ahead.
Sorry, I was trying to answer. But you're quoting positions from the St. Joseph County Right to Life. I'm not a member of that organization, and so I'm not responsible for statements that they make. The statement that I signed said what you and I have discussed, and it said nothing further than that. And as for, what policy position someone might take, as I've said to your colleagues, it's not up to me to be in the business of expressing views, and I am happy to talk about views that I expressed when I was a private citizen, but now I'm a judge, and so I cannot publicly express views.
Just to be absolutely clear, I'm not asking about the St. Joseph County Right to Life or their positions, and I understand you may or may not disagree or agree with them, but your legal position, IVF treatment, and I'm not going to ask again, just this last time, criminalizing it,
Well,
would it be constitutional? I think there's a clear answer.
but Senator, I've repeatedly said, as has every other nominee who sat in this seat, that we can't answer questions in the abstract. That would have to be decided in the course of the judicial process. With a case, some legislature would actually have to do that, and then litigants would have to come to court. There would have to be briefs and arguments and consultation with colleagues and opinion writing and consideration of precedent. So an off-the-cuff reaction to that would just circumvent the judicial process.
Well, again, I'm disappointed. I think Tracy would find that response somewhat chilling, because she and thousands, maybe millions of women, potential parents, would be horrified to think that IVF treatment could be made criminal. And I understand you're not answering the question, but I think she would be deeply fearful. Do you think that it would be constitutional to make it a crime for doctors or healthcare providers to provide that care or abortion care?
Well, Senator, again, that's a hypothetical question. And so, as I've said, to give off-the-cuff responses about abstract issues, and I should clarify to say it really doesn't matter if they're hard questions or easy questions. It's just any questions that call for an abstract legal opinion are not ones that are appropriate for me to give either as a sitting judge or as a nominee. Those questions in my judicial role can be answered only through the judicial process.
Just to be absolutely clear, there are millions of women like Samantha and Tracy and the veterans I mentioned who are terrified to think that their doctors and healthcare providers would be potentially in jail at risk of prosecution. Doctors who are exercising currently protected rights that Samantha says saved her life. And I believe our healthcare providers are heroes, particularly during the pandemic. But I want to ask you one more question about these documents. In the 2013 letter that you signed, there is the following statement. We renew our call for the unborn to be protected in law, and welcomed in life. What does it mean for, quote, the unborn to be protected in law? Does that statement mean there is no valid constitutional protection for an abortion, and therefore Roe v. Wade should be overturned?
I think that statement is an affirmation of life. It points out that we express our love and support for the mothers who bear them. Again, it was a statement validating the position of the Catholic university at which I worked in support for life and to, support women in crisis pregnancies, to support babies. So it's really no more than the expression of a pro-life view.
I expect we'll be talking more about this issue tomorrow. I want to move now to another topic. You and Senator Durbin and others talked about your dissent in Cantor v. Barr, and I think your approach here, in effect, usurps the legislature's appropriate role in making policy judgments. In the case of Cantor, which, by the way, you put first on the list of decisions that you thought were most important that you have written, is that correct?
I don't remember the order in which I listed them.
It was first.
I accept that. I just don't remember the order.
Okay.
I did list it. I remember listing it. But.
Okay. But that decision seems to usurp the legislature's role in deciding who should be permitted to have firearms and who should not, because you decided the legislature was wrong to classify felons as not deserving of firearms. You decided as a matter of policy that when they were not dangerous, they should have that right. That's a policy or legislative judgment. And I think it has huge ramifications for real people across the country. And I want to tell you about one of them from Sandy Hook, Connecticut. Natalie who is shown here with her brother Daniel. Daniel was killed at Sandy Hook Elementary School in Newtown, Connecticut on December 14th, 2012. Daniel was 7. I was there that day. I saw the parents after they'd learned that they had lost 20 beautiful children. And 6 great educators died as well. In the firehouse that day, there was unspeakable grief. And 8 years later, Natalie says that grief remains with her. But Natalie, like Newtown, is resilient and strong, and her grief and trauma have spurred hope and action. She and many young people across the country are leading a movement to deal with the epidemic and scourge of gun violence in this country. What happened at Sandy Hook was not an isolated instance. There have been 236 other mass shootings in the last decade. In the last 10 years, gun violence has taken more than 354,000 lives in rural communities and urban communities all around the country, and I'm sure in Indiana and South Bend as well. Your opinion in Cantor goes farther than Justice Scalia in Heller. In fact, you characterized it as kind of radical. It is, in effect, an outlier. And it is, in fact, radical.
Did I say it was radical in the opinion?
I think you said, quote, "It sounds kind of radical to say felons can have firearms." That's a direct quote.
Oh, I didn't remember that particular language.
You can.
I'm not, I just don't recall it, but I'm not nitpicking about it.
We can look it up.
That's fine, Senator. I don't think you're making it up, trust me. No, I'll check it and look it up, but I know that's not the thrust of your question.
It sounds kind of radical because it is radical. In fact, no courts of appeals, except maybe the Seventh Circuit, has adopted this reasoning.
The Third Circuit, I think, has a rule that's...
The Third Circuit. Any others?
I don't know that it's come up.
I knew there was
The
one
Third
circuit that did. I wasn't sure which one, but thank you.
My position was consistent with a Third Circuit en banc decision that had already been decided.
And cutting through all of the legalese, and we've had quite a bit of it going back and forth, what this approach does potentially is mean that Connecticut's gun safety provisions that the people of Newtown, Kristen and Michael Song, on behalf of their son Ethan, who perished because of a gun that was unsafely stored, they championed a measure called Ethan's Law. common sense measures that might have prevented the death of Shane Oliver, Janet Rice's son, who died on October 20th, 2012. Shane was killed when he was 20 years old in Hartford. He died fighting for his life in Hartford Hospital. And measures like the emergency risk protection order that Connecticut now has. 19 states have these laws. They've saved lives. And extreme risk protection order laws, which help minimize risk, might well be struck down under the reasoning of your dissent.
Respectfully, Senator, my dissent would not reach even those issues. My dissent was about the narrow question about whether a felon who had sold fraudulent foot inserts could automatically be disqualified from his Second Amendment rights simply on that basis. It said that guns can be kept out of the hands of the dangerous, and it didn't say anything about other gun safety or background check. Those are all issues that are being litigated across the country and were not at issue in Cantor.
But supplanting the legislator's judgment about when dangerous people should be protected from themselves if they are potential suicides, as Vic Bencomo, a veteran in Iraq, found when his friend was going to take his life. The emergency risk protection order would have been available, deciding what is dangerous, who is dangerous, when weapons should be taken away from them. If the courts are going to supplant the judgments of legislatures, if judges are going to legislate from the bench, that's the import of your reasoning in that dissent. It may not have dealt precisely with any of these particular laws, but the reasoning throws into doubt. It raises the risk to many of them. And folks who live in Connecticut are terrified of that prospect, at least many who've talked to me.
Sandy Hook was a tragedy. So I express the deepest sympathy for those who experienced that loss there and elsewhere. But Cantor, you know, I hope you take some comfort from Cantor being a much narrower decision that doesn't have any effect on those sorts of laws. Thank you, Senator Blumenthal.
Thank you. Thank you, Judge.
Senator Tillis.
Thank you, Mr. Chairman. Thank you, Judge Barrett. Mr. Chairman, before I get started, I'd like unanimous consent to submit a letter from my primary care physician indicating that I've fully complied with CDC guidelines and been cleared like 2,000 other North Carolinians yesterday, and I'm glad that they're healing.
Without objection.
I'd also like to put forth 3 letters in support of Judge Barrett, including one from Devin Patel, a former student who speaks very highly of your academic prowess, but also your compassion.
Without objection.
Also like to cover what Senator Blumenthal just did. I think we should go back. I believe you alluded to it, Judge Barrett, but question 12A of the committee questionnaire asks for books, articles, reports, letters to the editor, editorial pieces, or other published material you have written or edited. Is it fair to say that if you signed a petition, you did not write or edit any of the petition you signed?
I did not write or edit that.
It's also needs to be restated. I think you alluded to it, but over the last 6 justices confirmed by this committee, all of them provided supplemental information, and in some cases after the actual hearing. So I appreciate your being forthcoming, that you've submitted 1,800 pages of documents. Mr. Chairman, just going back, I also wanted to mention that as a part of my journey through my time in quarantine, I have enrolled in 2 studies so far. I'll be giving blood on Friday to enroll in another program at UNC Chapel Hill, and I'm scheduled to donate convalescent plasma. Because this is being aired, I hope that anyone who's recovered from COVID will do their part to try and heal this country from the health challenges that COVID has presented us with. I intend to do my part. I also would like to say I like to consider the Senate an essential business. And I believe that the architect of the Capitol and our attending physicians here have taken great measures to make sure that we can safely come to work. And I would encourage anybody who works in the Senate to come to work. I want to also go back to something that Senator Feinstein said earlier, and you're not going to have to answer this question. Senator Feinstein mentioned earlier that we've had a surge in applications for guns or purchases of guns. I wonder if a part of that is where we find our society right now. We're seeing great cities burned and looted. In my highway patrol in North Carolina, 75% fewer applications to go into the Troopers Academy and record high requests for retirement. We see that in New York. We see it across this country. I think people are afraid because many people, including people on this committee, are unwilling to condemn the acts of violence and public safety out there and condemn violence against law enforcement, which is rampant. I lost a sheriff's deputy just about a month ago who was shot protecting a family. So, yes, Senator Feinstein, I suspect that gun purchases are up, but I suspect the root cause behind a lot of them have to do with people's personal safety. To your family, I would encourage all your family members and your students who mercifully, or your children who are your students too, who are mercifully taking a break, to treat social media like roadkill. Just don't look at it, because if you do, you're going to regret it. I am going to also ask unanimous consent to put forth some articles or tweets from prominent people that I think kind of give you an idea of the guerrilla tactics that are being used right now. In the committee, this has sounded a whole lot like a lobbying session. It's almost as if you're being interviewed to become a U.S. Senator so that you can decide policy on the Affordable Care Act and a number of other things that I'll get to. But behind the curtains, we're seeing people say all kinds of things about you. One called you a white colonizer for actually adopting 2 Haitian children. We have another one calling you a handmaid and a clown car, and it will be submitted for the record, but the profanity used in there. Another one that says that, yeah, you're a good mom, but that doesn't qualify you as a judge. What qualifies you as a judge is being an extraordinary professor, an extraordinary student, and an extraordinary jurist. And I think that these people need to recognize doing the bidding of this committee by attacking you outside of the committee is as bad as them being in this chamber. Now, I also want to talk about the discussion on Roe v. Wade and the Affordable Care Act. Senator Feinstein, in I think the same 2 or 3 minutes, said that she wanted you to protect Roe v. Wade but overturn Heller. Those seem to be incongruent, but I'll just leave that out there. They're asking you to basically legislate. I don't want you to do that. But when we talk about Roe v. Wade, the one thing that's conveniently missed about this discussion is something that I think that most of the American people are at odds with the position that every member of the Democratic Conference supports. My granddaughter went to her 2-month health checkup today. She weighed in at 10.1 pounds. And you can't see this picture, but I'm telling you, from this granddaddy's eyes, she's gorgeous. But she was born 3 weeks premature, and she only weighed a little over 6 pounds. She was discharged from the hospital within 36 hours. My colleagues on the other side of the aisle want to talk about the broad strokes of Roe v. Wade. They don't want to talk about their radical policy that would allow the right to take that child away that I just held in my arm 2 or 3 weeks ago, and 8 weeks ago when she was 3 weeks premature. Judge Barrett, I believe I have complete confidence in your integrity. I have complete confidence that you're going to go and you're going to be a great justice. But I do want to ask a little bit about maybe your experience when you were working for, actually, I want to start when you were in school. When you came in, you were obviously a brilliant student. You did your homework. We've heard professors attest to your intelligence and your performance in school. Did you ever go into a classroom where the professor was espousing one position and you were espousing another one, and you ended up coming out with a different perspective?
Sure.
Yeah. Did you ever change your professor's perspective?
Well, I'm not sure about that.
Well, it's kind of an unfair balance. Okay, now fast forward to when you were a clerk for Justice Scalia. I just saw an interview last week when I was in quarantine of Justice Breyer talking about these mounds of documents that his clerks would provide him. He'd quickly go through them. He said it's actually a fairly quick process to winnow out the ones where there's no dispute among, there's no split circuits, so you move through it pretty quickly. I understand that Justice Scalia, at least in some sessions, would have a mix of clerks. They would be across the ideological spectrum. Was that the case when you were clerking for him?
I would say that not all four of us, he had four clerks, and we were not all of the same mind. There was a mix.
Were there ever cases when you went before Justice Scalia and you thought that maybe he was leaning one way where he actually listened to the arguments from the clerk and modified his position? Or was it like the professor discussion?
No, I think he definitely listened. I mean, we would go in before an argument when he was preparing, and he would pepper us with questions and go back and forth. He wanted to hear it from all sides. And so, no, he definitely, it was part of the give and take, though, to be clear, he was the one with the commission, and he was the one who made the decisions.
Thank you. The last thing I'm going to say, because I want to yield back more time than most other members, is, Mr. Chairman, you opened up this morning talking about the Affordable Care Act. I don't think there's anybody in the U.S. Senate that doesn't want to make sure that every single picture that we've seen here, that those folks have affordable health care and that they can be cared for. But what we have here in the Affordable Care Act is something that is so flawed that the majority of the Democratic candidates for president all raised their hand and said it needed to be replaced with something they call Medicare for All, which could be Medicare for none. We know the broken promises of if you like your doctor, you could keep it. If you like your health care, you could keep it. What we're not talking about are the thousands of people who were already forced off of their job health care because employers changed hours, and now instead of working one full-time job, you've got to work two full-time jobs because the businesses can't afford it. We've got a fundamental problem here. We need to protect every one of them, but we also need to make sure that people who have a health plan under the Affordable Care Act can actually afford to use it. In the catastrophic situations, it's life-changing, and thank God that it's there for them. But what about so many other people that only have it and will only use it if they have a catastrophic situation because they can't afford the co-pays, they can't afford the underlying cost? We need to fix that. We shouldn't expect a justice or the Supreme Court to fix it. That is our job. We should all show up here for work, and we should get that done. And we should also work on all the other things that this country is suffering from as a result of COVID. Thank you, Judge Barrett. I look forward to supporting your nomination.
Thank you, Senator Tillis.
Thank you. Senator Hirano.
Thank you, Mr. Chairman. Mr. Chairman, I want to reiterate my objections to holding this nomination hearing instead of working to provide relief for the millions of Americans who are suffering during this pandemic. 3 weeks ago, our country crossed a tragic milestone. We lost more than 200,000 Americans to COVID-19. That is more than the entire population of the Big Island in Hawaii, more than the population of Tempe, Arizona, Cedar Rapids, Iowa, Wilmington, North Carolina, Charleston, South Carolina, Waco, Texas. I could go on. 200,000 American lives plus. This is a photo of a memorial outside the White House where President Trump held a reckless super spreader event 2 weeks ago to announce the Supreme Court nomination. The memorial shows 20,000 empty chairs, one chair representing 10 American lives lost to COVID-19. And one of those chairs represents Veronica Guevara's grandfather, who is pictured here with Veronica. Veronica, who is from Iowa, has experienced the painful impact of the Trump administration's failure to address the pandemic. Her family is composed of essential workers who are working on the front lines of this pandemic. Her mother, who worked at a fast food processing facility, caught COVID-19 at work and was eventually hospitalized for 7 days. Thankfully, her mother recovered, but then her grandparents got COVID-19 and were admitted to the hospital. And although her grandmother recovered, sadly, her grandfather didn't make it. After experiencing all of this tragedy, Veronica shared, quote, "It is even more so insulting to see a Senate that is more concerned with rushing through a Supreme Court nominee rather than focusing on providing relief to all the hardworking people that gave them their current leadership positions." End quote. Many Americans agree with Veronica. They are sitting at their kitchen tables wondering how they're going to buy food, how they're going to pay rent. Millions of them are they don't have jobs. They're going to food banks for the first time in their lives. So rather than coming up with a bill that meets the needs of the urgency of this moment, Republicans are just coming up with piecemeal bills. That's because we know that within your own caucus, you can't agree on one bill that fits the critical needs of this country. In fact, there are at least 20 Republicans we heard who have said, "We're done, we're not doing any more to help the Americans who are suffering with COVID." So here we are racing forward with this nomination, while the rest of the country is wondering, what the heck is the Senate doing, particularly the Senate Republicans? So I agree with all the people in our country who are asking, what the heck? This is hypocritical. This hearing shows the American public exactly what my Republican colleagues' priorities are, ramming through another ideologically driven justice to the Supreme Court instead of helping the people in our country suffering during this pandemic. Mr. Chairman, I have some letters of opposition to Judge Barrett's nomination to enter into the record. These are letters from Lambda Legal, the Japanese American Citizens League, and the National Asian Pacific American Women's Forum, which was joined by 55 reproductive justice groups. I ask unanimous consent to enter these letters into the record.
Without objection.
Judge Barrett, Chief Justice John Roberts has recognized that, and I quote him, "The judicial branch is not immune," end quote, "from the widespread problem of sexual harassment and assault, and has taken steps to address this issue within the judiciary. As part of my responsibility as a member of this committee, and indeed all of the committees on which I sit, to ensure the fitness of nominees for a lifetime appointment to the federal bench or to any of the other positions for any of the committees on which they appear, I ask each nominee these two questions, and I will ask them of you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator Hirono.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
Judge Barrett, do you think it is appropriate for justices to consider real-world impacts in their decision-making, as Justice Ginsburg noted in a number of her dissents?
Well, Senator, the doctrine of stare decisis is a good example of that because the factor reliance interests takes into account the real-world impact, the way that people have ordered their affairs and relied on decisions. So there are contexts, yes, in which considering the impact is expressly part of the doctrine.
So you would say then that you've been listening to all of us here yesterday as well as today talk about the real-world impact of the striking down of the Affordable Care Act, and would all of those impacts be factors that would be important for you to consider should you be a justice?
Senator, to be clear, I have the utmost empathy. The stories, that you have told, including the story of Veronica's family, are very moving. If I were a justice, the commitment that I would make to you and all people affected by the laws is that I would follow the law as you enacted it, and I have no agenda. I would not be coming in with any agenda. I would do equal justice under the law for all and not try to thwart or disrupt in any way the policy choices that you and your colleagues have adopted.
So are you saying that the impact of the Affordable Care Act on the millions of people who rely upon it, that those who you would deem to be policy considerations that we should address?
Senator, I think that you choose the law, and you've structured the Affordable Care Act. It's a complex, long statute. I think you set the policy, and then I think when a court has to interpret the statute or decide how it applies in a certain circumstance, the court looks to traditional legal materials, looks to the briefs. It listens to the real-world impact on the litigants who are before the court arguing the case, because every case affects real litigants. Every case affects real people. I said in my opening statement yesterday that, when you pass statutes, they're often named for the co-sponsors of the bill. But cases decided by all courts are typically named after the parties. They affect real people.
Judge Barrett, so are you saying that all of the stories that we brought forth yesterday and the millions of people who are relying on the Affordable Care Act can rely upon you, that those impacts would be considered by you, that you would consider those to be legal arguments that you would consider? Because when you say that you're going to make a decision based on the law, the real-life stories that we've been talking about, you would consider those to be part of the law?
Senator Hirono, every case that comes before a court, because as I was saying earlier, no case comes before a court unless it involves real live people who've had a real live dispute. And it is the job of a judge deciding every case to take into account the real world consequences of the parties before it.
So does that mean that you would agree with Justice Ginsburg that the court should be taking into consideration the real-life effect of the decisions that they make? Because she wrote a number of dissents saying that the majority did not consider the real-world impacts of their decisions. So are you aligning yourself with Justice Ginsburg in terms of what you would consider real-life impacts and the effect it would have on your decision regarding the law?
Well, Senator, I don't know what context, the particular context in which Justice Ginsburg was describing that. I think what I'm trying to align myself with is the law, and that I will take into account all factors, including real-world impacts, when the law makes them relevant, as it clearly does, for example, in the doctrine of stare decisis.
I'll get to your views of precedent in a moment. I'll give you a real-life example of Justice Ginsburg. In Ledbetter v. Goodyear Tire and Rubber Company, Lily Ledbetter worked at a Goodyear plant for 19 years. As an area manager, a position held mostly by men, Lily was paid less than all of her male counterparts. When she eventually realized this stark inequality, she sued for pay discrimination, and a jury agreed. But the Supreme Court kicked Lily's claim out of the court for being too late. The conservative majority, including your mentor, Justice Scalia, interpreted Title VII's 180-day time limit to mean that Lily had to have filed her claim within 180 days of when her salary was decided, instead of accepting the common-sense approach of viewing her paychecks as an ongoing part of pay discrimination. Justice Ginsburg strongly disagreed with her conservative colleagues' approach to the case. In her dissent, she pointed out the many challenges women face in discovering pay disparities, including how many companies keep salaries confidential. In a stinging rebuke, she said, quote, "The court does not comprehend or is indifferent to the insidious way in which women can be victims of pay discrimination," end quote. In another case, in 2018, in Epic Systems Corp v. Lewis, employees who had been illegally underpaid joined together to seek back pay in court. To block this effort, their employers forced them to sign an arbitration agreement prohibiting collective actions. They actually had to sign these arbitration agreements in order to even have a job or keep their job. So the Supreme Court's conservative majority, including Justice Scalia, sided with the company. They interpreted a general federal arbitration law to override two worker protections laws instead of recognizing that the worker protection laws fall sensibly within the exceptions in the arbitration law, meaning that the worker protections laws should prevail. Again, Justice Ginsburg strongly disagreed with the majority's approach to the case. In her dissent, she pointed out that blocking joint lawsuits would deter most workers from seeking individuals' unpaid individual unpaid wage claims because of the cost of lawsuits and fear of retaliation. She warned the majority's decision would result in hurting vulnerable, low-wage workers. Now, those are the kinds of real-life impacts. The reality of women who are not paid the same as their male counterparts because of sex discrimination happening that she has no way of finding out about, or of workers who are forced to sign an arbitration clause that overrides worker protection, other worker protection laws. Those are the kind of real-world impacts. So do you think Justice Ginsburg was wrong to consider real-world impacts in her decision-making?
Well, Senator, both the case, you're talking about Lilly Ledbetter, both that case and Epic Systems are precedents of the court. And as I've said a number of times during the hearing, I can't really comment or grade thumbs up or thumbs down, as Justice Kagan put it, prior precedents, or say how I would have decided them.
They are, Judge Barrett, they are precedents of the court that do not take into consideration the real-world factors at play here. And in fact, in the case of Epic Systems, the court sided with the corporation as opposed to the workers who are trying to remedy a wrong. And in Lilly Ledbetter, she was totally out in the cold. So again, the court did not. So they established precedent, all right, but it was a precedent that was not based on real-life impacts. So much as you sit here telling me that you would follow the law, after all, the law, for example, the Affordable Care Act, that law embodies a policy that says we want as many people as possible to be covered under insurance. And if the Affordable Care Act is struck down, that policy, that law, would be struck down. So I know that there was some discussion about some distinction that you make about policy versus the law, and I find that distinction to be a fiction, because every law, or most laws we pass, are supposed to have real-world impacts. Otherwise, why should we pass a law? So the fact that you're not able to, I think it's pretty clear. Let me rephrase that. You do consider Justice Scalia to be your mentor, that your judicial philosophy is in alignment with him, and I think we all acknowledge that Justice Scalia and Justice Ginsburg were at pretty much opposite ends of the spectrum. So since Justice Ginsburg made it a policy, her approach was to look at the real-world impact. Justice Scalia's was not. So I'd say that when it comes to the Affordable Care Act, the real-world policy considerations that will not be taken into consideration by the conservative judges would mean that 23 million people could lose their health care, that 133 million Americans with pre-existing conditions could lose critical protections for their health care, and more than 7 million Americans who have tested positive for COVID-19 would probably be added to the group of people with pre-existing conditions, and millions of Americans would once again face lifetime limits on coverage for essential services. That 8.7 million women would lose coverage for critical maternity care services, and we know that Black and Native women are 2 to 3 times more likely to die than white women from pregnancy-related cases, that Americans could lose coverage for essential health benefits like prescription drugs and mental health care, that young adults will no longer be able to stay on their parents' health insurance plan until age 26 at a time when our country is dealing with massive job losses. So in my view, you have posed an artificial distinction between policy considerations that's left up to us and following the law, because if your criticism of Justice Roberts' decision in upholding the Affordable Care Act, if that was something that he followed, he would have struck down the Affordable Care Act. That is your, if he followed your criticism of him in sustaining the Affordable Care Act, he would have struck it down. So I would conclude that your approach is, in fact, not like that of Justice Ginsburg, who did care. about what would happen. Let me just tell you one story of a person who will be impacted in the real world if the Affordable Care Act is struck down. And I know that so many of my colleagues have already established that the president expects you to strike down the Affordable Care Act, and you've already established that you made no such commitments. But clearly that is why this whole process is occurring so that you can be sitting on that court in time to hear the Affordable Care Act by the Supreme Court on November 10th. So one of the people who will be impacted is Elizabeth from Texas. She moved to Texas for a job and thought that she would have a stable income and health care coverage. And all that changed when her hours decreased and she lost her health insurance. Because she couldn't afford health insurance, she couldn't get proper treatment for her asthma. She had to resort to using friends' expired inhalers and over-the-counter remedies. The ACA allowed her to get health insurance again. The ACA also protects people with pre-existing conditions like Jordan, who I talked about yesterday, and she has a very rare illness that would require $500,000 per year just for her medication. And were it not for the Affordable Care Act, she wouldn't be able to afford it. I mean, who can afford $500,000 a year to keep her going? And also people like Kimberly. I talked about her yesterday. The ACA enabled her to get a mammogram, which she wouldn't have been able to get, and that mammogram revealed that she had breast cancer, and she got a mastectomy. So, you know, the real life impacts on people like Elizabeth, Jordan, and Kimberly, where you say you will follow the law, it really leaves me wondering whether all of these real life impacts are what you would call within the scope of the law that you would decide should you be confirmed. November 10th, you'll hear the case. You will be deciding on the constitutionality of the Affordable Care Act. And by the way, you noted that the issue in the Affordable Care Act was one of, what was it that you said?
Severability?
Severability. But the other issue in the Affordable Care Act is the entire constitutionality of the law, because the district court, the issue was whether the district court in Texas was correct in deeming the entire law unconstitutional. So in fact, we are facing the entire law falling by the wayside. Let me move on. So you've been also asked a lot of questions about whether or not you would overturn Roe v. Wade. I mean, clearly President Trump expects that you would do so because, as he said, if we put another 2 or perhaps 3 justices on the court, that'll happen, meaning the reversal of Roe v. Wade will happen automatically, in my opinion, because I am putting pro-life justices on the court. And a number of us have mentioned that Senator, as far as Senator Hawley is concerned, where he said, I will only vote for those Supreme Court nominees who have explicitly acknowledged that Roe v. Wade was wrongly decided. And there's a whole quote I have from him, but after you were nominated, Senator Hawley made clear that you passed his litmus test. And he said, I think her record is awfully clear. I think that's one where she meets my standard of having evidence in the record. And by the way, he had noted that he expected this evidence in the record, not from your post-nomination assurances to him. So all your prior record, he said, you met his standards. So we usually expect justices to uphold and apply long-standing precedent. So was the president wrong in concluding that you would vote to overturn Roe v. Wade?
Well, Senator, again, I can't make any statements, no hints, forecasts, or previews, as Justice Ginsburg put it, about any case or any precedent, but I will repeat what I've said, throughout this hearing, that I made no promises to anyone. I have no agenda. There are 598 volumes of the United States reports. That's something that judges build on. Justices don't go to the court to start having a book burning.
I know that you have reiterated that time and again, but what we are left with are the positions that you have already taken. So the 2006 newspaper ad you signed that said you, quote, oppose abortion on demand and defend the right to life from fertilization to natural death. It's not just the fact that this newspaper ad you joined said what I just read, but it also said, quote, it's time to put an end to the barbaric legacy of Roe v. Wade. In a 2013 speech you gave where you said the Roe decision quote, permitted abortion on demand, end quote, after you said you opposed abortion on demand in 2006. So what underscores my concern about your willingness to overturn Roe v. Wade, which is really the expectation that the president has and which Senator Hawley fully expects you to do because you have met his litmus test. But you noted stare decisis, which is precedent. And you have argued that a justice's duty to follow the Constitution, which you explain means that she should, this is regarding your view on precedent, that she should, quote, enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it, end quote. So in fact, you say constitutional cases are the easiest to overrule because you bring your own assessment of what the Constitution requires. And as you said, if the precedent is clearly in conflict with your view of the Constitution, then the precedent falls by the wayside. So you did indicate that there are a few cases that are immunized from overturning because they wouldn't be challenged in the first place, i.e. Brown v. Board of Education. But Roe isn't one of those cases because we know that there are all kinds of challenges to Roe, basically because the states are very busy passing all these laws that limit a woman's right to an abortion. So you also said in that speech that even if Roe is not overturned, you said, without overturning Roe, you explained, quote, the question is how much freedom the court is willing to let states have in regulating abortion. And so there are 14 cases right now relating to state abortion restrictions making its way through the circuit court, and some of these are going to land in the Supreme Court. And these 14 cases include the following restrictions. 6 cases involve bans on abortion starting at gestational ages ranging from 6 to 24 weeks. 2 cases involving bans on a particular type of procedure, dilation and evacuation, that accounts for nearly all second trimester abortions. 1 case involving a requirement that fetal remains be buried or cremated. 4 cases involve laws imposing unnecessary requirements on abortion providers, like transfer agreements with local hospitals. 4 cases involve so-called reason bans. 2 cases related to parental notification and consent. There are real reasons why the American public is concerned that you will overturn Roe or basically strip it of all meaning so that it becomes a nullity, because you will have these cases that, as you say, you know, the open question is how far the Supreme Court will go in letting states put limits on abortion. So that is why a lot of people are very concerned about your views as articulated pre-nomination, which convinced Senator Hawley you met his test. This morning, Senator Feinstein asked you a question about the Supreme Court's 2015 decision in Obergefell v. Hodges, a case in which the court recognized the constitutional right to same-sex marriage. And I was disappointed that you wouldn't give a direct answer on whether you agreed with the majority in that case, or if you instead agree with your mentor, Justice Scalia, that no such right exists in the Constitution. So even though you didn't give a direct answer, I think your response did speak volumes. Not once, but twice. You used the term sexual preference to describe those in the LGBTQ community. And let me make clear, sexual preference is an offensive and outdated term. It is used by anti-LGBTQ activists to suggest that sexual orientation is a choice. It is not. Sexual orientation is a key part of a person's identity. That sexual orientation is both a normal expression of human sexuality and immutable was a key part of the majority's opinion in Obergefell, which, by the way, Scalia did not agree with. So if it is your view that sexual orientation is merely a preference, as you noted, then the LGBTQ community should be rightly concerned whether you would uphold their constitutional right to marry. I don't think that you use the term sexual preference as just, I don't think it was an accident. And one of the legacies of Justice Scalia and his particular brand of originalism is a resistance to recognizing those in the LGBTQ community as having equal rights under our Constitution. In 1996, Justice Scalia wrote a dissenting opinion in Romer v. Evans defending a state's ability to openly discriminate against the LGBTQ community. In 2003, Justice Scalia wrote a dissenting opinion in Lawrence v. Texas defending a state's right to criminally prosecute someone for same-sex sexual activity. 10 years later, in U.S. v. Windsor, Justice Scalia wrote another dissenting opinion, this time defending the federal government's right to deny federal recognition of same-sex marriages. And of course, 2 years after that, in Obergefell, Justice Scalia wrote yet another dissent, and this time he argued that there was no constitutional right to same-sex marriage. So under Justice Scalia's judicial philosophy, which you have told us is your own, states could openly discriminate against the LGBTQ community. Same-sex couples could be denied the right to get married, and they could actually be thrown in jail if they engaged in sexual intercourse. There are an estimated 11 million adults who identify as LGBTQ living in this country since Obergefell was decided in 2015. Approximately 293,000 same-sex couples have gotten married. And many of these people are rightly afraid that if you are confirmed, you will join with other conservative members of the court to roll back everything the LGBTQ community has gained over the past 2 decades and push them back into the closet. Now, 2 sitting justices are already calling for Obergefell to be narrowed, if not outright overturned. Just last week, Justices Thomas and Alito issued a statement concurring with the court's decision to deny cert in Davis v. Irmo, a case involving a former Kentucky County Court who refused to issue marriage certificates to same-sex couples. They accused the court of, and this is Justices Alito and Thomas, they accused the court of, quote, reading a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text. And these 2 justices signaled that Obergefell is a problem that only the court can fix. So, coupled with your use of the term sexual preference, coupled with your view on precedents, and that a justice's view or her own analysis of the constitutionality should overtake or overcome precedents if it's in conflict. So this is why so many people in the LGBTQ community are so concerned that you would, in fact, join the signaling that these 2 justices have already put out there, that Obergefell will fall by the wayside. Thank you, Mr. Chairman.
Thank you. Senator Ernst.
Thank you, Mr. Chair. And Judge Barrett, thank you so much for being here today with your beautiful family. Yet once again, we appreciate the support that you are showing to Judge Barrett by being here today. And Judge, I just want to offer you the opportunity at this point. Is there anything from earlier today that you feel you need more time to respond to?
Thank you, Senator Ernst. I would like to just make a quick follow-on to some of Senator Hirono's comments. One, I've said a number of times during the hearing that I can't comment or grade existing precedent, and I want to be clear that the point of doing that is not to say whether I agree or disagree with it. It's not to implicitly signal that I do disagree with it. It's designed to be neutral. So in saying that I couldn't opine on whether Obergefell was rightly decided or not, I was certainly not indicating disagreement with it. The point of not answering was to simply say it's inappropriate for me to say a response. And the second point was to say that I certainly didn't mean and, would never mean to use a term that would cause any offense in the LGBTQ community. So if I did, I greatly apologize for that. I simply meant to be referring to Obergefell's holding with respect to same-sex marriage.
Thank you for that. I appreciate the clarification, and it goes back to the discussion that you had with Senator Sass on the black robes. When you put that robe on, you are neutral, correct?
Yes.
Yes, thank you. So I did want to go back because the issue of coronavirus has come up yet once again in the committee room. And I just wanted to make a point and clarify that the Senate GOP did bring up a relief bill a number of weeks ago. And in that bill, there was a $300 boost in weekly unemployment insurance benefits. There was a second pass at Paycheck Protection Program for our small businesses. There was additional $105 billion for K through 12 schools and colleges with new scholarship programs, and $15 billion to help working parents find accessible childcare options. There were supports for farmers and ranchers impacted by the pandemic. There was $31 billion for development and distribution of vaccines, drugs, and other medical supplies, $16 billion for testing and contact tracing. There was loan forgiveness for the Postal Service, liability protections for our schools and healthcare providers, and an expanded charitable deduction for contributions made during this pandemic, and many, many other things. It was a very, very good bill. It was what we could agree upon, but I would note that Senate Democrats did block those provisions that would have gone to help families like Veronica and others in Iowa that are suffering from the pandemic, and of course, our greatest sympathies to those that have been impacted all across the United States. So, Mr. Chairman, I would like to enter into the record. There's 3 letters here for the committee and an op-ed, a letter of support from 48 Christian women scholars. The second is a letter from a group of governors all across the country, including our own Iowa's Governor Kim Reynolds, strongly supporting the nomination of Judge Barrett. The third is a record letter from Tracy Lovett, who was with Judge Barrett while they both served on the SCOTUS clerk class of 1998. And then there's also an editorial by Derek Moeller, a professor of law at the University of Iowa College of Law, that appeared in the Gazette of Cedar Rapids, Iowa. And this professor had Judge Barrett as his evidence professor at Notre Dame Law School. And he does say she treated all law students from all backgrounds with dignity and respect. If I could have those entered into the record.
Without objection.
Thank you. And Judge Barrett, I am pro-life. I am pro-life. And I see that, judged by your faith, and as has been aptly pointed out many times over by our colleagues across the aisle, that you are pro-life. But once again, can we reiterate your stance as a judge?
So as a judge, my personal moral beliefs, which I have not, that I can think of, I'm not expressing them publicly right now, because now that I am a judge, I can't sign statements like that one that I did 15 years ago. But my policy views, my moral convictions, my religious beliefs do not bear on how I decide cases, nor should they. It would be, it would be in conflict with my judicial oath.
And I know that you consider yourself to be an originalist, as you discussed earlier with Senator Sass. And it seems that adhering to the originalist view would naturally lead a judge to carry out her constitutional duty of impartiality when applying the law. And adhering to this philosophy as a judge takes real courage. And the courage you have displayed thus far as a federal judge prompted a coalition of groups to send me a letter supporting your nomination. Susan B. Anthony List led this coalition letter that I would like to submit to the committee for the record. And I know this is going to make a number of members on the committee just very squeamish because they are a pro-life organization. But with this in mind, I want to take a moment to read part of this letter. Quote, Judge Barrett has proven herself to handle disputes impartially, approaching cases as a textualist and originalist who loves the Constitution. She is a jurist who rightly leaves politics to politicians and legislating to legislators. And I'll quote further. Quite apart from whatever policy views she may have on the matter, Judge Barrett reasons to a proper result in each case before her. As a federal appellate judge appropriately following controlling precedent, in February 2019, she joined a panel decision upholding a law creating a buffer zone around abortion facilities. This buffer or bubble zone case being referred to is Price versus City of Chicago. Judge Barrett, could you please give us an overview of the city ordinance that was challenged here and explain how precedent established by the Supreme Court's Hill decision influenced your reasoning of the case?
Yes, I was on a panel. There was a challenge to a bubble zone ordinance, which essentially means it was, how to describe it, it limited where abortion protesters could go to do sidewalk counseling or leafleting were the things that they identified as the activities they desired to undertake in the expression of speech outside of the abortion clinic. The Supreme Court has a case called Hill versus Colorado, and that case said that such bubble zones, especially because this one in Chicago was nearly identical, as I recall, with the one that was at stake in Hill, said that they did not violate the First Amendment. And so our panel, you know, we're bound by that precedent. Our panel applied that precedent. And so as you say, that was a case involving abortion, but my duty as a judge was to follow the governing law, and that governing law in that case was Hill.
Absolutely, and thank you for that clarification. And I think it was important to point that out because in that case, using precedent, it did favor that abortion clinic. Is that correct?
That is correct.
Thank you very much. So I would like to submit this for the record. Thank you. Now turning to a topic of agency rulemaking, really sexy topic, not something that we have talked about as of yet. But as I mentioned yesterday, when Congress makes laws that overstep the Constitution, it can be felt all across the state of Iowa, whether it's in the streets of Council Bluffs, Iowa, or in the farm fields over in Clinton County. But Congress isn't the only body capable of overstep. Executive agencies can be just as guilty of this as we've seen in Iowa. In 2018, as a judge on the 7th Circuit, you helped decide a Clean Water Act case, specifically Orchard Hill Building Company versus Army Corps of Engineers. The decision found that the federal government did not provide enough evidence to justify its decision to deem 13 acres of Illinois wetlands as a water of the U.S. I'm very supportive of a less expansive definition of WOTUS and am encouraged by how you approach this decision. Farmers in Iowa are also encouraged by this development. I believe then, as I do now, that the Obama administration's Clean Water Rule, or the WOTUS rule, was unconstitutional. But I also want to talk to you about agency rulemaking that I believe was constitutional, which is illustrated in a case that the 10th Circuit Court has recently ruled on, specifically Renewable Fuels Association versus EPA. At issue in this case were 3 exemptions the EPA granted to oil companies, allowing them to avoid their obligations to blend renewable fuel under the Clean Air Act's renewable fuel standard. These oil refinery exemptions, which were not disclosed to the public, were challenged by renewable fuel producers who said that they only found out about the waivers because of investigative news reports. The 10th Circuit concluded in this case that the renewable fuels producers were injured by the EPA's exemptions and thus had standing to sue. The court also found that the EPA exceeded its statutory authority in granting those petitions because the agency may only extend previously existing waivers. In the case of these 3 refiners, there was nothing to extend because they had let their exemptions lapse. In other words, the 3 refineries had not received continuously extended exemptions in the years preceding their petitions as required by the statute. However, in the wake of this 10th Circuit decision, small refineries flooded the EPA with 67 petitions for retroactive waivers, some dating back as far as 2011, in an attempt to go back in time and establish a chain of continuously extended exemptions. These oil companies have also appealed to the 10th Circuit decision to the Supreme Court. So while I'm not going to ask you to speak on all of this and what is going on, the problem here, bottom line, is that the EPA wasn't following the law. They took the law that Congress passed, they twisted it and interpreted it for the benefit of oil producers, and that harmed our Iowa farmers. I know, again, you can't speak on how you would rule on these cases, especially those that could be pending before the Supreme Court. But tell me, how should they interpret the laws that are passed by Congress?
Well, I think that the court's role in reviewing the lawfulness of agency action, it's largely governed by the Administrative Procedure Act, which governs the way that agencies can do their business and outlines what their authority can be. There's also a doctrine called Chevron, which is named after a case. Right. And many times, if we're talking about a Chevron issue, we're talking about an issue of statutory interpretation. It sounds like that's mostly what you're thinking of. And an agency, you know, when a court reviews whether an agency has exceeded its lawful authority, it goes to the statute that you and Congress enact and interprets that statute, looks at the text, and tries to tell whether you've given the agency, given the EPA in your example, leeway to adopt policies. And that leeway would be present if you had ambiguity in the statute that left the decision to the agency. But if the agency goes farther than the text of the statute permits, then it is the role of a court to say that that action, you know, was in conflict with the statute and therefore illegal.
And what happens then if there is an actual question on the intent of the law?
Well, a statute in this context, in a context of a Chevron-type challenge to agencies, an agency's interpretation of it, you would interpret the statute in the same way that you would interpret any other statute. So as I was talking with Senator Sass about earlier, my own approach to it would be textualism. And so in my approach to language, the intent of the statute is best expressed through the words. So looking at what the words would communicate to a skilled user of the language.
Very good. Well, I appreciate it. We do have a little bit of time remaining. So again, I just want to thank you. I want to thank your family very much for lending their support to you through this process. It can be a bit grueling. But I do have to say, though, your temperament throughout the entire hearing has been truly commendable. So thank you so much. I look forward to working with you further. And with that, Mr. Chair, I will reserve my time.
Thank you, Senator Ernst. Judge, are you okay to do 2 more?
Sure.
So Senator Booker, Senator Crapo, then we'll take a 20-minute break to grab a bite to eat and finish up. Senator Booker.
Thank you, Mr. Chairman, Your Honor.
Hi, Senator.
So I spoke yesterday, and I appreciate the attention which you gave me talking about how this is not a normal time. And I want to reiterate that one more time as cogently as I can, because this is something like we've just never seen before in the history of the United States. We're not just days away from Election Day, but people are actually voting right now. Close to 1 million people in my state have already voted, and about 10 million people voted nationally. The only other time a Supreme Court nomination hearing happened this close to an election was, as you probably know, was under President Lincoln, who declined to offer a nomination before the election. But we are in the midst of an ongoing election right now at a very contentious time in our democracy. It's probably not normal also because people are already speaking in this election, and it seems like we are rushing through this process when many of my colleagues on this committee said just 4 years ago that we should not proceed to fill a vacancy that opened 269 days before an election. And the words of some of my colleagues, including the chairman, was to use our words against us. We would not do exactly what we're doing right now. It's also not normal, clearly, because we're in the middle of a pandemic. And we have tens of thousands of new COVID infections every single day, widespread food insecurity like we haven't seen these kind of food lines in my lifetime, I don't think. People across our country are struggling, and unfortunately, we see that we are right now not dealing with this crisis. We are instead literally having closed the Senate virtually, and the only proceedings that are being allowed to go forward are not the issues of helping people who are struggling, but dealing with this. And it's not normal that we have a president who has repeatedly attacked the legitimacy of our institutions. So much so, and I've never seen something like this in my lifetime, that his former cabinet members, his former chief of staff, all talk about the danger he represents to the country we all love. In fact, probably one of the most respected person on both sides of the aisle, General Mattis, who served as our Secretary of Defense, went as far as to say, a man who has been very reserved in his comments, that Donald Trump is a danger to our democracy. We are at a time that the legitimacy of our institutions are at stake. And it's not normal that the president would further cast a shadow over your nomination as well as the independence of the court by saying he would only nominate justices who would tear down Roe v. Wade, who would overturn ACA. And it's not normal amidst this all, and again, something that I find hard to believe that we're talking about, is that we have a president who cannot commit himself to the peaceful transfer of power. Now, in the light of this abnormality, most Americans think we should wait on your nomination. It's an illegitimate process. Most Americans think that we should wait. Today, and I appreciate you not following the news, but 90 of your fellow faculty members from Notre Dame wrote an open letter calling on you, for the sake of our democracy. They didn't speak to whether you're right or left or your judicial philosophy or qualifications. They wrote an impassioned letter for the sake of our democracy. They publicly issued a statement asking that your nomination, that you withdraw from this nomination process and have it be halted until after the November election. This is not normal. And again, the overwhelming majority of Americans want to wait, but my colleagues here are not listening. And so I'm going to ask you some questions that if you had told me 5 years ago that would be questions asked at a Supreme Court nomination hearing, I would have thought they wouldn't be possible. But unfortunately, I think they're necessary to ask you. And I hope that you'll give me direct answers. The first one, you've already spoken towards issues of racism and how you deplore it. But I want to just ask you very simply, and I imagine you'll give me a very short, resolute answer. But you condemn white supremacy, correct?
Yes.
Thank you. I'm glad to see that you said that. I wish our president would say that so resolutely and unequivocally as well. But we are at a time that Americans are literally fearful because their president cannot do that in the resolute manner in which you did. I'm sorry that that question had to even be asked at this time. Here's another one. Do you believe that every president should make a commitment unequivocally and resolutely to the peaceful transfer of power?
Well, Senator, that seems to me to be pulling me in a little bit into this question of whether the president has said that he would not peacefully leave office. And so to the extent that this is a political controversy right now, as a judge, I want to stay out of it, and I don't want to express a view on.
So, Judge, I appreciate what you've said about respecting our founding fathers, about the originalism. It's remarkable that we're at a place right now that this is becoming a question and a topic, but I'm asking you, in light of our founding fathers, in light of our traditions, in light that everyone who serves in that office has sworn an oath where they, quote, swear to preserve and protect and defend the Constitution of the United States, I'm just asking you, should a president commit themselves, like our founding fathers, I think, have a clear intention, like the grace that George Washington showed, to the peaceful transfer of power? Is that something that presidents should be able to do?
Well, one of the beauties of America from the beginning of the Republic is that we have had peaceful transfers of power. and that disappointed voters have accepted the new leaders that come into office. And that's not true in every country. And I think it is part of the genius of our Constitution and the good faith and goodwill of the American people that we haven't had the situations that have arisen in so many other countries where there have been, where those issues have been present.
Thank you, Your Honor. Do you think that the president has the power to pardon himself for any past or future crimes he may have committed against the United States of America?
Well, Senator Booker, that would be a legal question. That would be a constitutional question. And so in keeping with my obligation not to give hints, previews, or forecasts of how I would resolve the case, that's not one that I can answer.
Well, I think I agree with you that it is an issue right now, something I never thought would be an issue before, but it is an issue that our president may intend to pardon himself for future crimes or past crimes. If a president is personally responsible for several $100 million in debt while he's in office, potentially to foreign entities, do you think he has a responsibility to disclose who his lenders are, especially given the emoluments clause?
Well, Senator, there's litigation about the emoluments clause. I think it was in the Fourth Circuit. I don't know where it stands, but that clearly is an issue that's being litigated, and one present in courts is not one on which I can offer an opinion.
Thank you. I think it's disturbing that we're having this conversation. I think it's disturbing that we have a president that has brought what should be settled in the minds of most Americans. Presidents should reveal what their debts are, especially if they're to foreign nations. Presidents should not be able to pardon themselves for future crimes. Presidents should condemn white supremacy. Presidents should commit themselves to the peaceful transfer of power. Judge Barrett, you've seen a lot of my colleagues and I put up pictures of people in this room and the stories we've told, and I've appreciated the way you've listened. It's not a stretch to understand why a lot of Americans are afraid right now. All we have to do is look at the statements and actions of my Republican colleagues, the Republican Party platform, and the president who nominated you, and even some of your own words, which have been read by my previous colleagues around the Affordable Care Act. President Trump, who nominated you for this vacancy, has not only explicitly stated that the Supreme Court should overturn the Affordable Care Act, but he promised that he would nominate a judge who would, quote, do the right thing, unlike Bush's appointee, John Roberts, on Obamacare. The president has tried to do this legislatively. He's tried to do it administratively. He's failed time and time again, but he's promised over and over again to tear down the Affordable Care Act. Meanwhile, all of my Republican colleagues on this committee, except for one, has voted to overturn the Affordable Care Act because House and Senate Republicans have tried to do it 70 times. The one Republican who did not was an attorney general who joined 20 state attorney generals who sued to overturn the Affordable Care Act. You yourself said, and now I will quote you, that Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. The same Chief Justice Roberts that Trump implied didn't do the right thing. And so, Judge Barrett, you have said that if you were on the court, you will hear and consider the arguments from both sides. I was actually very interested when you said that you would put your family members in the shoes of litigants on both sides. Given all that you've heard said over and over again about the intentions to tear away the Affordable Care Act, to end the Affordable Care Act, given what you've heard about the people who rely on it, given the commitment, that President Trump's said explicitly to only appoint judges who would overturn the ACA, is it unreasonable for people to fear, putting yourself in the shoes of people, is it unreasonable for the people that have been up here in their pictures, is it unreasonable for them to fear that the ACA would be overturned if you were confirmed to the court?
Well, Senator, I want to stress to you, Senator Booker, as I've stressed to some of your colleagues today, that I am my own person. I'm independent under Article 3, and, I don't take orders from the executive branch or the legislative branch.
I understand that. I guess, can I restate my question? Because I don't think you are understanding it. Sure. I'm just asking you as an act of empathy, can you understand the fears that are exhibited by the people we put up? The two people I put up, Michelle and Merritt, I don't know what their political party is. I don't know if they're going to vote for me. I'm on the ballot. I don't know. I just know that there were people that wanted their voices to be heard because they are afraid right now and what your nomination represents. All I'm asking is, can you empathize with that? Can you understand that?
Senator, I can certainly empathize with people who are struggling. I can empathize with people who lack health care. You know, one of the things that was so striking to me when we went to get our daughter Vivian from the orphanage in Haiti was the lack of access to basic things like antibiotics. And it just made me appreciate the fact that we had access to health care. So I can certainly empathize with all of that. And with respect to the ACA, you know, should I be confirmed? And as I've said, I would consider the issue of recusal a threshold question of law and whether to hear that case. But should I be confirmed and should I sit and hear the case? As I assured you, I would consider all the arguments on both sides. And one of the important issues in that case is whether, even if the mandate has become unconstitutional since it was zeroed out, whether it would be consistent with the will of Congress for the whole act to fall. It's a statutory question, not a constitutional one, or whether the mandate could be severed out and the rest of the act stand. And so the task of every justice who hears this case will be to look at the structure of the statute and look at its text to determine whether it was the will of Congress when they passed the ACA.
And Judge, I apologize, especially after the good behavior that was noted, that we shouldn't be talking over each other.
No, that's okay, Senator.
My time is running quickly.
Sure.
I guess I just, as a guy who looks at justices, I was just asking you to express that you understand the fear that's in America right now, because you heard story after story of people who don't know if they're going to be able to afford their health care, who don't know if they will be denied insurance coverage. And I'm going to move on because of the short time, but I was just asking you, can you understand the fear giving a president that has said that they will put justice on there that will tear down the Affordable Care Act, thus taking away health care from millions of Americans? There is fear in our country right now. But I want to move now to earlier what Senator Durbin and you discussed. They asked about your views on racism and the role of courts in addressing racial justice. I was troubled that you said that racial justice and equality, and I'll quote you, or how to tackle the issue of making it better, those things are policy questions. I think that that's the quote. How to tackle the issue of making it better, the racial injustice, those things are policy questions and not for the court. The federal government's own data, and this is, I think you and I referenced this in our private conversation, which I appreciate. You said you were familiar with a lot of the data about the discrimination within our criminal justice system. For example, the U.S. Sentencing Commission shows that prosecutors are more, this is the U.S. Sentencing Commission said that prosecutors are more likely to charge black defendants with offenses that carry harsh mandatory minimum sentences than similarly situated whites. Are you familiar with that, the U.S. Sentencing Commission?
I'm not familiar with that particular.
Does that surprise you?
I mean, I don't know, Senator Booker, that seems an odd thing for me to express an opinion out. As you
I'm not asking you, these are facts. These are just facts.
And as you and I am not familiar with that study. As you and I discussed, I am aware that there is evidence and that there have been studies of systemic racism or implicit bias in the justice system. So I am aware of that issue. I was not aware.
You're aware of evidence that there is implicit racial bias?
I am aware that there have been studies showing that implicit bias is present in many contexts, including in the criminal justice system.
Okay. I'm just going to read some of these other statistics because I think they're really important, and this is independent data from the U.S. Sentencing Commission. And black defendants, again, are compared with similarly situated white defendants who are subject to 3-strike sentencing enhancement at a significant higher rate, which on average added 10 years to sentences. You're not familiar with that study?
I'm not familiar with that study.
Do such cases come before the Seventh Circuit?
The 3 strikes cases?
Yes.
Are you talking about the 3 strikes, the Prison Litigation Reform Act cases where they're struck out, or are you talking about?
I'm asking cases in the criminal justice system that relate to racial bias. Do they come before the court?
So certainly we have discrimination cases. Certainly there are 1983 cases or Title VII cases.
I would imagine so. And in your research for those cases, you familiarize yourself with a lot of the data on the discrimination within the system?
That, we familiarize ourselves with the arguments the parties make and the information that they put in the record. And in some cases, I have had parties submit, or it's submitted in the district court technically and then made part of the record.
And so I just want to be clear. Do you believe that there is, in fact, implicit racial bias in the criminal justice system?
Well,
Which is just a yes or no question. Do you believe, in fact, that there is implicit racial bias in the criminal justice system?
Senator, it would be hard to imagine a system, a criminal justice system as big as ours, not having any implicit bias in it.
So is that a yes?
Senator, yes, I think that in our large criminal justice system, it would be inconceivable that there wasn't some implicit bias.
Okay. Over the last 2 years, about 121 of President Trump's judicial nominees to the federal court have said unequivocally that there is implicit racial bias within the justice system, quite clearly. I'd like to turn to an opinion you wrote last year about race discrimination, Smith versus Illinois Department of Transportation. The case involved an African-American traffic patrol officer who had been fired from the Illinois Department of Transportation. This employee claimed that he had been subjected to hostile work environment and that the supervisor called him the N-word. But you ruled that the employee had failed to make the case that he had been fired in retaliation for his complaints about race discrimination. And now you acknowledged that, quote, and I'm going to quote you now, the N-word is an egregious racial epithet, but you went on to insist that the employee couldn't, quote, win simply by proving that the N-word was uttered at them, and that he failed to show that his supervisor's use of the N-word against him, quote, altered the conditions of his employment and created a hostile or abusive working environment. And you said that even based on his own subjective experience, this black employee had, quote, no evidence that his supervisors were lashing out at him because he was black. I'm very surprised to have to make this point at all, but even a staunch conservative like Justice Kavanaugh, in my questioning of him, spoke to the obvious harm here in a way that you don't seem to. He wrote in a Court of Appeals case that, quote, being called the N-word by a supervisor suffices by itself to establish a racially hostile work environment. And you disagreed with that. Why do you believe that the law recognizes the harm that is inflicted on a black person in this country when they are called that word by their work supervisor, or by anyone really for that matter, and all the history dredged up in that word, centuries of harm? Why do you believe differently than Justice Kavanaugh?
Well, Senator Booker, that opinion does not take a position different than Justice Kavanaugh. It expressly and was written very carefully to leave open the possibility that one use of that word would be sufficient to make out a hostile work environment claim. The problem was that in that case, the evidence that the plaintiff had relied on to establish the hostile work environment involved other, he was driving the wrong way down a ramp, and then expletives were used, not the N-word. And the N-word was used after his termination had already begun. And he didn't argue under clear Supreme Court precedent. I didn't make up the objective-subjective element. Under clear Supreme Court precedent, both are required. And he didn't say that it altered the terms of, that's not how he pled or made his case. And it was a unanimous panel decision.
And forgive me if I'm reading this case wrong, but you're saying to me he was not claiming that he had a hostile work environment, and that it is in the fact pattern that this supervisor called him the N-word, and that does not constitute a hostile work environment in the way that Justice Kavanaugh said clearly that it does?
No, Senator, I think you're mischaracterizing what I said, with all respect. In that opinion, the evidence that he introduced to show the hostile work environment was the use of expletives when he drove the wrong way down. He was hired to be a safety driver for the Illinois Department of Transportation, and he based his hostile work environment claim on the use of expletives at him based on poor work performance. That was what he relied upon, and then his termination proceedings had begun. He didn't tie the use of the N-word into the evidence that he introduced for his hostile work environment claim. And so as a panel, we were constrained to decide based on the case the plaintiff had presented before us. So the panel very carefully wrote the opinion to make clear that it was possible for one use of the N-word to be enough to establish a hostile work environment claim if it were pled that way.
I'm going to turn to the AutoZone case you discussed earlier with Senator Feinstein. The initial panel of 3 judges that examined the case ruled against Kevin Stuckey. You were not a part of that initial panel, but you did have an opportunity to vote on whether to hear the case before the entire court. You had an opportunity to affirm the bedrock principle enshrined in Brown versus Board of Education about separate but equal, really to say that separate is inherently unequal. But you voted no. You didn't think the full court needed to examine this deliberate segregation of employees by race. But the judges on the court disagreed with you. In fact, 3 judges explained, we know that, quote, deliberate racial segregation by its very nature has an adverse effect on the people subjected to it. On one of the essential teachings of Brown versus Board of Education, which I know you're familiar with, is that idea of separate being inherently unequal. Why did you think that these separate but equal facilities were lawful, or why didn't you see this as a practice that was worthy of closer scrutiny?
Senator, as I said earlier to Senator Feinstein, I did not make a merits decision on that case, and I wasn't on the initial panel. The calculation of whether to take a case en banc is different than a merits determination. So I wasn't reaching any decision about whether Title VII applied to that situation or not. Federal Rule of Appellate Procedure, I think it's 35 that governs en banc proceedings, sets out standards, and this case didn't create an intra-circuit conflict or an inter-circuit conflict. And so I didn't think it met federal rule of, all my vote means is that I didn't feel like it satisfied the elevated high standard for en banc review, not that I thought it was correct. There's a lot of deference to panels in my court.
Right, but I mean, 3 judges disagreed with you, and these were judges appointed by Republican and Democrat presidents. They saw the case about separate and equal really compelling. They thought the issue deserved closer scrutiny, and you had an opportunity to join them, but you didn't. You referred earlier to the problem of implicit racial bias in our system, this idea that despite the color of our skin, people can get a hearing, people can get justice. And this denial, it seems to me that you disagree with the prioritization, at least, of your 3 colleagues.
Senator, 8 of my colleagues chose not to take the case en banc, and the en banc process is a different one than the merits decision-making process. To decide that case on the merits and know whether I would come out the same way, I would have had to participate in it and read the briefs and hear the arguments.
And so the 3 justices were wrong, then you disagree with your colleagues?
The 3 judges who dissented, my 3 colleagues whom I respect very much, thought that it met the standard for en banc review. That's a different question than the merits, and so I did disagree with them about whether to take it en banc. So I was within the group of 8 colleagues that decided that maybe that would be an issue we could take up in the future, but not to disturb the panel decision then. But that's not a merits determination.
Thank you, Your Honor. Thank you. Moving quickly, Judge Barrett, 5 years ago, the Supreme Court ruled that the Constitution protects the rights of same-sex couples to marry. This was a Obergefell case, which has been discussed today. The court declared the Constitution grants LGBTQ Americans equal dignity in the eyes of the law. Hundreds of thousands of couples have built their lives on this decision. I've married some of them myself. On that day 5 years ago, the court fulfilled really that ideal of equal justice under law. And yet now the same-sex marriage is legal. We've seen efforts to try to undermine that decision. Justice Ginsburg wrote about legal rules that would, quote, create 2 kinds of marriage, full marriage and skim milk marriage. I firmly believe that our laws shouldn't allow discrimination against people on the basis of who they are. I have a number of questions on this topic, if I can get through them, but I wanted to offer you a further opportunity to address the issue that I don't think you got to fully address that my colleague brought up. When you did use the term sexual preference earlier today, rather than sexual orientation, is there a difference, and what is it?
Senator, I really, in using that word, did not mean to imply that I think that, that it's not a matter of, that it's not an immutable characteristic or that it's solely a matter of preference. I honestly did not mean any offense or to make any statement by that.
But by what you just said, you understand about that immutable characteristic. In other words, that one's sexuality is not a preference, it is who they are. Is that what you're saying?
Senator, I'm saying I was not trying to make any comment on it. I fully respect all the rights of the LGBT community. Obergefell is an important precedent of the court. I reject any kind of discrimination on any sort of basis.
So you say Obergefell is the decision. Well, what about your two colleagues, excuse me, forgive me. What about Alito and Thomas, who have said that the court has created a problem that only it can fix? They clearly don't see that as a precedent worth following. You just said Obergefell is a precedent.
I said Obergefell, of course, Obergefell is a precedent. It is an important precedent. As you pointed out, there are reliance interests now on Obergefell as to why Justices Alito and Thomas have called for its overruling in the recent opinion that they issued. I can't really speak to.
They call it a problem. Do you know what they're referring to?
Well, Senator Booker, I don't know what Justices Thomas and Alito were thinking. That you'd have to ask them.
So we're now seeing cases where gay and lesbian Americans are being denied equal access to Social Security survivors' benefits. One same-sex couple in Arizona was together for 43 years, got married, but one of them died 6 months later, and now the surviving spouse is being denied benefits because they weren't married long enough after 43 years together in love. Does this violate the rule of equal treatment that the Supreme Court has laid down?
Well, in Obergefell, could you repeat the facts of this?
They were together for 43 years. The law changed and allowed them to marry. They married. One died soon after, and they're being denied survivor benefits because they weren't married long enough because the law wrongfully denied them that equality.
So that would be a legal question that would have to come up and be decided in the context of a real case. I mean, it's plain that Obergefell recognizes the full right of same-sex couples to marry, but the question of what are the implications of that for benefits would be something that would come up with before a court later.
But there are some precedents. Maybe I can ask a different question. Can a hairdresser refuse to serve an interracial couple's wedding because they disapprove of interracial marriages?
Well, Loving versus Virginia follows directly from Brown, and it makes unconstitutional any attempt to prohibit or forbid interracial marriage.
Could they refuse to serve a black couple's wedding?
Could a baker or a florist refuse to? Title VII prohibits any sort of discrimination on the basis of race by places of public accommodation.
How about an interfaith wedding?
Well, Senator, I feel like you're taking me down a road of hypotheticals that is going to get me into trouble here because, as you know, I can't opine on how cases would be resolved, and I've said that whether they're easy questions or hard questions, I can't do that.
So I'm not the lawyer that you are, but you seem to honor the precedents that are enough to protect discrimination against African Americans, interracial couples, but you stop on saying that unequivocally about people stopping on religious discrimination or against a Muslim couple's wedding or an interfaith wedding?
Well, Senator, I think, you know, what Title VII says, as I'm sure you know, is Title VII prohibits discrimination on the basis of race, on the basis of sex. All I can do is say refer to the statute. But of course, as to whether there would be evidence to show or whether any particular encounter between a customer and a florist or a baker violated Title VII, that would be a case that would have to come up, you know, as I discussed with Senator Sass, with real litigants, litigated on a full record. So you're asking a series of hypotheticals.
And so I'm assuming that you will not respond, or for the same reasons you've uttered before, you will not respond about whether a florist can refuse to serve a same-sex couple.
Well, it sounds like you're on your way to talking about Masterpiece Cake Shop and some of the cases that are very hotly contested and winding their way through the courts. And so I want to make sure that I'm not in a position where I'm eliciting any views that would bear on litigation that's very active.
Well, and I guess you maybe can understand if we go back to the question that both I and Senator Hirono asked you about what you said you didn't mean to offend about whether it's a choice or not. These are about, are they immutable characteristics of an individual, like their race? I just want to just close by saying the story of some folks in my home community of New Jersey, Emily, Sonessa, and Jan Moore. They've been together for 51 years. They've raised 3 children. At last count, and I think that that's a good way of putting it, they have 18 grandchildren and 20 great-grandchildren. And you know how families are. Mm-hmm. But for a long time, they had to keep their relationship and their love a secret. Finally, once same-sex marriage became legal, they got married. And thanks to the Supreme Court's decision in Obergefell, they can now enjoy their full rights. Judge Barrett, you're asking the United States Senate to agree to have you replace Justice Ginsburg, which would tilt the balance of the court further to the right. Remember that it was Justice Ginsburg who warned against full marriage for some couples and skim milk marriage for others. Like so many couples in my state of New Jersey and around the country, Emily Jan are worried about what might happen if the Supreme Court starts to peel back some of their hard-fought rights. They believe that their love should be valued by their government and equally as the love of any other people. And they believe a lot of the rights that they now enjoy, which were denied in the past to African Americans even, to interracial couples, they believe that they should be able to preserve them. And so my time's expired. You've been very generous, and as has the chairman, in allowing me to go over. I'm grateful to have the opportunity to talk with you more tomorrow.
Thank you, Senator Booker.
Thank you very much.
Thank you, Senator Booker. Senator Crapo. Then we'll take a break for supper. Thanks.
Thank you, Mr. Chairman. And we're 4 away from the finish today. Before I begin, I do have a couple of letters I'd like to submit for the record. One from the Speaker of the Idaho House, Scott Bedke, in support of Judge Barrett's nomination, and the other from the National Shooting Sports Foundation, also in support of the nomination, Mr. Chairman.
Without objection.
Thank you. And Judge Barrett, I am going to, well, I'll get to some new material, but a lot of what I do at the beginning will be going over things you've already said, and you must think you've said them way too much, had to say them way too many times. I'm going to just be sure that we get some things nailed down once more. Before I do that, though, there's been a lot said today that really needs to be responded to. This won't be a question to you. These first two, I'm just going to quickly respond to a couple of them. The first was one of my colleagues, Senator Whitehouse, spent a very long presentation trying to make the case that there is a lot of dark money out there trying to control the Supreme Court nominations and this whole process and the situation that we face today. I just want to set the record straight. These are actually some statistics that Senator Cruz quickly went through when he spoke. But yeah, there is dark money in politics, and I think that we should get it out. What this means is that money where you don't know who the real donors are behind the entity that's making the expenditure. Fortunately, we're getting a lot of that out, but there's still a lot there. The impression, though, that was left was that this dark money is all on one side. The reality is, if you look at opensecrets.org, this data is from 2016, but I've seen data even later into 2018. And it's the same kind of statistics, and that is that really the significant majority of the dark money is being spent in favor of the Democratic side rather than the Republican side. Of the top 20 organizations and individuals that they identified who contribute to super PACs, who then utilize the money in the way that was talked about, 14 of them give exclusively to Democrats. Of the top 10 on that list, only 2 give to Republicans. So, and the totals, by the way, were $422 million in this report going to Democrats and $189 million going to Republicans. So yeah, there is money in the system which we can't identify. A lot of this money, by the way, is going into ads against you, Judge Barrett. But we can't get it all out yet. I think we ought to get it out, but let's not try to create the impression that this is just some one-sided circumstance that's happening in the country. The other thing I want to go over first before I get into my questions is the same thing I went over yesterday because the allegations have been made again and again and again that somehow we are rushing this case and somehow we are violating the history and the precedent of the way the Senate operates and the way the presidency operates when there is a vacancy in an election year. Some people count these things differently. There's a statistic that I will use that will count all vacancies that have happened, whether the vacancy occurred in the election year or whether it just didn't get resolved until the election year. But it doesn't matter whether you just take the ones that arose in the election year or if you take all of them that were resolved in the election year. The precedent is the same. It's overwhelming. In every single case, the sitting president made a nomination. Every case. In those cases in which the Senate was of the same party as the president, I'm going to use the one for all of the nominations that actually were dealt with in an election year. There were 29. 19 of them were when the party was the same as the president. 17 of those 19, the party moved ahead with the president's nomination, and the nomination was confirmed. 10 of those times, it was when the party was not the party of the president. In 9 of those cases, the party that was not the party of the president declined to move forward until the next president was elected. Now, that's the precedent of the Senate. That's what happened in 2016 when the Senate was of a different party than the president, and it's what's happening now when the Senate is the party of the president. And those are the facts, and that's the precedent. In terms of the timing, I went through the timing then as well. I think your hearing started, Judge Barrett, on the 16th day from the day you were nominated. There's a bunch of members of the Supreme Court whose nominations hearings started sooner than that, including Ruth Bader Ginsburg. And so the fact is that normal procedures, appropriate timing, and appropriate policy and precedent is being followed here as we move forward. Now, having made those points once again, like I said, I will get into some new questions for you, but I'm going to go over a lot of things that you've already talked about because I really think it's important that we just make it as clear as possible. You've talked about originalism and textualism. Is there a difference between those two things?
They are the same basic approach, but we use originalism mostly to refer to interpreting the constitutional text, and textualism we use to refer to interpreting statutory text. But they both involve the same principle, which is that one comes to the law and interprets it as it would have been understood by those at the time of either its ratification in the case of the Constitution or its enactment in the case of a statute, and that the law remains the law until it's lawfully changed through democratic processes.
All right, thank you. And I assume you would consider yourself both an originalist and a textualist.
I do, Senator Crapo.
And you've written quite a bit about precedent and stare decisis. Could you just once again tell us what that is? And maybe you could make a distinction between what it means at the appellate level and at the Supreme Court level.
Sure. So there are two kinds of stare decisis. There's horizontal stare decisis, which is, say, the Supreme Court's obligation to follow its own precedent. And then there's vertical stare decisis, which is my obligation right now on the Seventh Circuit to follow Supreme Court precedent because it sits above me in the federal judicial hierarchy. For vertical precedent, there's no question. I mean, I can't buck what the Supreme Court does. It sets the precedent and all lower courts must follow it.
Right.
For horizontal precedent, for example, on my own court right now on the Seventh Circuit, the court that renders a precedent does have the ability to reconsider it under certain circumstances. Otherwise, errors don't get fixed, and Plessy versus Ferguson would still be the law of the land.
So, and you will, I'm sure, tell me, what are the rules there when you do horizontal reevaluation?
Sure. So when a court decides whether or not to overrule a precedent, it considers, first of all, is it wrong, and how egregiously wrong is it? You know, that we can see in the Brown versus Board of Education decision how that factor played. You also consider reliance interests because, as I said before, stare decisis is short for stand by the thing decided and don't disturb the calm. So courts don't recklessly get in the business of just stirring up, disrupting people's lives, unless it's the other factors counsel in favor of doing it. You consider whether the law has developed since the precedent in a way that undercuts the foundations of the precedent itself. Same for the facts. You also consider whether the precedent that you set has proved to be workable for the courts below you that must follow it. So in my case on the Seventh Circuit, that would mean the district courts. Have we set out an articulation of the law in a case that lower courts can actually use?
And so, to paraphrase here, if a judge in a horizontal situation, either a Supreme Court justice evaluating Supreme Court precedent or a circuit court judge evaluating the circuit court's precedent, if they felt the precedent was wrong, that's not enough.
That is not enough.
And you have to have then the reliance and the other factors all falling into the right circumstance before a decision to actually overrule or overturn a precedent is made.
That's true, and this might be a good time, Senator Crapo, for me to make one other point about horizontal stare decisis doctrine. Earlier, and I can't remember which interchange it was, someone was pointing out, that I said stare decisis should have weaker effect in constitutional cases. That's actually what the Supreme Court has said. That's a well-established principle of stare decisis doctrine itself. The court has said that it gives super strong effect to precedent in statutory cases because you all can always step in and fix any errors of statutory interpretation the court might make. But the court itself has expressly said that it gives weaker stare decisis effect in constitutional cases because the only way to remedy an error is by constitutional amendment. So I just want to be clear that that is simply a restatement of the court's own doctrine. That wasn't something I invented.
All right, I appreciate that. And you also mentioned earlier that there are some, I think you said 6 super precedents?
Let's see, I can't remember how many are on the list, but as I said, it's in constitutional law scholarship. There are some precedents that scholars have identified as utterly beyond question that no serious person ever calls for their overruling.
Could you, I think Brown versus Board of Education would be one of those?
Marbury versus Madison, which establishes the power of judicial review. Let's see, the cases, probably easier for me to just identify what the precedents stand for. So
Sure.
The power of judicial review, the power of the Supreme Court to review judgments from state courts, the proposition that the 14th Amendment applies only to state action, the incorporation of the 4th Amendment, and by implication the other Bill of Rights, other rights in the Bill of Rights against the states. So they're mostly structural kind of foundational principles, and they're just so settled no one seriously challenges them anymore.
Thank you. I appreciate that. I think that that's very helpful. And in this hearing, you've been asked about at least 3 very significant Supreme Court precedents, and you've been asked whether you were asked to commit to overturn them or whether you've even had conversations with the president or his staff about them. One, and I just want you to, again, give your answer on that because I want this to be very clear. Roe v. Wade, have you had any conversations with the president or with the White House staff, White House counsel, anyone, and have you made any commitments about how you would rule on any case dealing with that?
I have not, Senator Crapo.
Thank you. And the same set of questions with regard to Obergefell.
I've had no conversations with anyone in the White House staff about that case, my views of it, how I would rule.
All right. And then finally, the current case, California v. Texas.
No conversations at all.
All right. Thank you. Now, you also earlier testified that there's a difference between judicial decision-making and the process of making a judicial decision versus, say, the process you would make as a professor when writing an article or what have you. Could you just quickly get into that with me?
Sure. So a professor, when writing law review articles or doing academic critique, is kind of at a 10,000-foot level. You're not in the trenches like a judge is because you are not deciding it in the context of a real case with real litigants in front of you, the adversarial process where you have people on either side, where you hear arguments and you consult with your colleagues and you write your opinion. And I think one thing it's worth pointing out about the judicial process is that I have had the experience of changing my mind at various points along the way. I've gone into oral argument more than once thinking, I was going to rule one way, and then oral arguments changed my mind. Or I've gone into conference, and my colleagues have changed my mind. I've even changed my mind, and this is not uncommon on the court, once I started writing an opinion. Judges say, it won't write, which means what you thought was right when you started writing it, you realize actually didn't really work out. So I think that process and the fact that judges keep an open mind all the way through is evidence of how the judicial process really is unique in our system, and it is a different enterprise than academic critique.
Thank you. I've been able to observe that a little bit. I clerked on the Ninth Circuit Court of Appeals.
That's right, you told me that.
And so I've been able to observe that exact process in each of those steps that you talked about taking place. And you're right. That's how it happens when it's done properly. Next, I want to go to one more specific kind of process type thing to make sure we all understand it right, and that's the recusal. Interestingly, you've been asked by my colleagues on the other side to assure that you have made no commitments about case law, but that to give a commitment on recusal. You have said that there is a process for recusal as well, and that you would follow that. But could you please lay that out again, once again, for us?
Yes, recusal is a question of law because 28 U.S.C. 455, the recusal statute, actually obligates a judge to recuse in certain cases of either actual bias or apparent bias. And there are Supreme Court precedents interpreting the range of a judge's obligations under that statute. There are also, professional conduct committees to consult, and I think collaboration and consultation, as I've said before, with other justices is the typical practice according to Justice Ginsburg's description of it. So it is a legal question that's governed by statute and precedent, so it's not one that I can make an advance resolution of.
All right, thank you. Now I want to move to, frankly, back to California v. Texas, California v. Texas, and the pre-existing conditions issue that has been raised by a number of my colleagues here. We've heard a lot about the Affordable Care Act yesterday and today. I serve on the Finance Committee as well as the Judiciary Committee, and so this is an issue I really care about a lot. I'm passionate about ensuring that all individuals, especially Idahoans, have affordable, quality health care coverage, and making sure that they have coverage for their pre-existing conditions is especially important, regardless of what one thinks about the Obamacare legislation. Reasonable people can disagree about the totality of the success of Obamacare, and this is something that I think should be remembered. But many of the policies in Obamacare were policies on which we had agreement between Republicans and Democrats as we moved forward at that time trying to craft a health care law. People may recall this was being negotiated in the Finance Committee for quite a while before President Obama pulled it back and then brought his own statute out. And one of the things that we had agreement on was protecting pre-existing conditions back then. There was no fight over that. And in fact, I think every single U.S. senator wants to protect access to coverage for patients with pre-existing conditions, Republicans and Democrats. So here we are now talking about the Obamacare legislation that was pushed through the Senate when there was a Senate and a president of the same party and the ability to avoid a filibuster. And we're now looking at legislation challenging one part of that. Again, you've talked about this, but I'd like you just to set up this next question. There's a difference between NFIB versus Sebelius, the case which you have made some commentary on, and Texas v. California. Could you tell me the difference?
Yes, NFIB versus Sebelius involved whether the mandate violated it was framed initially as a case about whether the mandate violated the Commerce Clause. And the majority in that case, as I've discussed in earlier interchanges, interpreted the mandate provision to be a tax rather than a penalty. And Chief Justice Roberts said that he thought it was justified as an exercise of Congress's taxing power, but would have been invalid under the Commerce Clause. Now, the new case that the Supreme Court is poised to hear involves a different question. If the mandate, which has now been zeroed out, the initial question, it does resemble NFIB versus Sebelius, because the initial question is something a tax if it's $0? So is it still a tax? And if it's not a tax, can it be justified under Congress's taxing power? But severability, even assuming that it is no longer a tax because it's zeroed out, the next question is, if that provision is unconstitutional, does just that provision become inactive, so to speak, or does the whole statute fall? And that is the question of severability. So in some respect, whether one thought that the mandate was unconstitutional or not, the act would have to be found, that would have to be unseverable.
And you may not know the answer to this, but I believe that in the last session of the Supreme Court, 7 members of the court said that there's a very strong presumption in favor of severability rather than knocking down an entire statute.
That is true. It's an established doctrine, and it was reiterated even last term.
So did you participate in a moot court case on this last month or in the last near future?
I did.
Can you tell us what a moot court case
Sure.
is?
So William & Mary Law School has every year what it calls its Supreme Court preview, and it includes a moot court case. There's a long tradition of moot court exercises at law schools. Sometimes they're called mock trials. Sometimes they're called moot courts. That's when they're appellate. And it's a chance to educate the community around the law school, the students, or in the case of this William & Mary program, it also draws in people from around Williamsburg so that they can see how the judicial process works.
And
So
judges often participate in moot courts, right?
judges often participate in moot courts, and in this particular one, there were maybe comprising the panel. The conference involved several other events, but this moot court involved a panel. It was supposed to be a mock argument for this case, and there were about 4 judges, a couple law professors, and some journalists who were on the panel with advocates fleshing out the case so that we did it by Zoom because of the pandemic, but so that students could see how the process might look.
And so what did the moot court decide?
Well, I do want to preface this, Senator Crapo, by saying it was an educational exercise.
I understand.
So it was made very clear to the audience, both at the outset and then in the deliberation room and then outside, that it was not designed to reflect the actual views of any of the participants, and nor could it, because, this was show up, you're not reading the briefs, diving deep down, and, a lot of times people change their votes in the deliberation room just for the sake of mixing it up and making it interesting.
I understand, and I appreciate you making that clear.
I just want to make clear the context. The vote was in the panel, the majority said that the mandate was now a penalty and was unconstitutional but severable. I think there was also a group in a minority who said there was no standing. To be honest, now I can't remember. Maybe there was, I could be wrong about this, and I feel like there was maybe another minority that said it wasn't unconstitutional.
And how did you vote?
Remember that. I voted to say that it was unconstitutional but severable.
All right, so you voted in favor. The one clue we might have as to your thoughts on the issue, even though this was just an exercise and you didn't have the whole case presented, and I understand that, but I'll just say to the viewers, the one clue we have is your ruling in this moot court case. And I think that's kind of an answer, frankly, to a lot of those who are raising this specter that you're going to try to take the whole Affordable Care Act away from everyone because of this very narrow case that is in front of the Supreme Court.
Although I do want to be very clear, Senator Crapo, for the record, that it wasn't designed to reflect my actual view. So to the extent that people think I might have been signaling to the president or anyone else what my views on the Affordable Care Act are, they couldn't have taken any signal from that.
I understand.
But I wasn't trying to signal anything because it was a mock exercise.
It was a mock case. It was a moot court. I understand that very much. Let me just go into a couple of other issues here. In fact, I can hit them very fast. Senator Ernst mentioned the Orchard Hill versus Army Corps of Engineers case on the waters of the United States. That is a big deal in Idaho and, frankly, in most of the western United States, in fact, most of the entire United States. And I appreciated your ruling, and I'm just going to tell you, I'm not going to ask you a question about it. I appreciated your ruling. I am going to ask you a question about the Chevron doctrine. And this is one of those you may not be able to respond to, but would you tell me what the Chevron doctrine is?
Sure. So I got into this a little bit with Senator Ernst. The Chevron doctrine is the doctrine that when a statute is clear, then that's end of case. But if Congress passes a statute that's giving an agency authority, or that's describing the boundaries of an agency's authority, and there's ambiguity in that statute, then the court will treat that ambiguity as a delegation to the statute, a delegation to the agency to fill in the details.
Yeah, and I'll just tell you, I disagree with that doctrine. I think that the courts ought to have the ability to interpret the statute, and if it's ambiguous, they should interpret it as best they can, and that the interpreter in our system should not be the agency that is enforcing the statute. I think the courts should oversee this. Now, that's just my opinion. So the question that you probably can't answer is, what's your opinion?
You're right, I can't answer, Senator Crapo.
Okay. Well, thank you very much. I just had another couple of quick questions. I was going to go into the Heller case. Well, I will ask you. Tell me, what do you believe the basic ruling of Heller is?
The basic ruling of Heller is that the Second Amendment protects an individual right to bear arms for self-defense.
So, so if I were to characterize it as that the Heller case reaffirmed that the right to bear arms is one of the rights guaranteed in the Bill of Rights to individuals.
That is what Heller held.
That's what Heller held. Okay. You know, I do have a number of additional questions which were just kind of softballs. But
I like softballs. I'm fine with that.
maybe you deserve softballs right now, but I think instead I'll give you the break. And you can
like
have
that too,
you
Senator
can have the
Crapo.
last 5 minutes of my time, or you'll get done 5 minutes sooner. Thank you very much for being willing to do this. You are an outstanding nominee, and I'm very glad to be able to support you.
Thank you, Senator Crapo.
Thank you, Senator Crapo. With that goodwill in mind, we'll break and we'll come back, say 6:50. It'll give us about 30 minutes to grab a bite, and we'll start with Senator Harris when we get back.
What's the I? What I heard though was that the judges on the case, they all voted, but nobody knew on each individual. No, now, I wonder. I mean, they reached the decision, but they didn't break it down. They didn't break it down. Oh, no.
Okay.
Meatball. Just so one, yeah. They'll need to buy them.
And you're watching C-SPAN's live coverage of the Amy Coney Barrett Supreme